So, good evening, everybody. Thank you for taking the time to join this Farm Advisory Service webinar that looks at the impact of the Employment Rights Bill on agricultural employers. So, this webinar this evening is funded by the Scottish Government's Farm Advisory Service. So, for tonight's webinar, I will be chairing the webinar. For those of you who don't know me, I am Mary Dalgleish, representing the Farm Advisory Service this evening. I work for SEC Consulting, who are subcontracted to deliver the Farm Advisory Service contract. So I'll be keeping an eye on the question boxes tonight and putting in your questions to our speaker for this evening, who is Sophie Henderson of Greenburn HR. We've worked closely with Greenburn HR on a number of Farm Advisory Service webinars previously that you may have attended. Specialisms in HR, but also in the rural and agricultural sector, and they work with a lot of large farming clients, but also small farming businesses. So Sophie will be able to insert a lot of examples this evening relating to farms, agricultural and rural businesses that I think will add real value to this presentation. So without further ado, I will stop sharing my screen and I will let Sophie set hers up and get us underway with the content of tonight's webinar.
Okay, hopefully everybody can see that. Thank you very much for joining tonight. I know it's a longer session, and I was saying to Mari that these employment law sessions never attract a massive crowd because they're quite traumatic. I will try my best to not make it so. As Mari said, Greenburn has worked in the agricultural sector for over 20 years. We have a lot of experience working with a variety of agricultural clients and non-agri businesses as well. I will pepper tonight's webinar with examples, hopefully to bring to life some of the things that we have been talking about, and hopefully to give you a bit of context as well. As Mara said, please feel free, if you do have questions, drop them in as we go. More than happy to pick them up. But I do know that the theme of tonight's webinar, there's a lot of information. So if you have stuff, we do have a break put in, and we can pick up things at the end as well. And obviously, we're happy to answer questions and give advice offline as well, if that's your preference. So let's crack on. The Employment Rights Bill, what we're going to be discussing tonight is, what is it? The Employment Rights Bill, you've probably heard of it. It's something that every political party has, but we're now talking about the proposals within Labour's Employment Rights Bill. What are the proposed changes to employment law? How will these impact agricultural employers? And what do you need to do to avoid any repercussion or to minimize risk for your business? I will try not to trot through this at 100 miles an hour. So if I do, or if we're going too fast, please also just drop a note in the chat. First off, Labour's Employment Rights Bill. You have likely heard things, you'll have seen big headlines about flexible working and making work pay, which is the current motto. So really, what is it? It is a proposed piece of legislation in the United Kingdom, aims to reform and enhance workers' rights. It is a central policy. Every party has it. And the promise is always to make a new deal for working people. Labour's, as I said, current motto is to make work pay. As part of their 2024 manifesto and their subsequent announcements, the bill is intended to strengthen workers' rights quite significantly and shift the balance of power more toward the employee and to trade union. Labour stated that they would introduce new workers' rights within the first 100 days of government. These would see a significant shift in employment law. And although it does not appear that there would be retrospective application, meaning that if they put something into law, it doesn't look at the retrospective practices, it doesn't look at the history, there would be an immediate target on all current employers. So the recommendation is to be prepared for the changes ahead of schedule. Certainly when the proposals came out, obviously in 2024, we, as a business, proactively took steps to change practices within our client sites so that, one, it was less of a trauma to do the change, but so that actually the agricultural business could get used to the changes as well. Because let's be honest, paperwork is the admin part of HR and employment law is not the thing that we spend our day doing. Well, I do, but it's not what you spend your day doing. And we want to make that as easy as possible so that there's less chance of getting it wrong and we're minimizing those risks. As part of the proposal, Labour has developed a new watchdog, which would have unlimited powers to quote unquote punish employers for failures. It has been written into the bill. It has been written into the bill that they get unlimited powers, and so far that hasn't been challenged. And although I suspect a watchdog would quickly get caught up with admin, with red tape, no one wants to be on receiving end of an inspection. The Home Office, HMRC, and the Agri Wages Board are currently focusing on Scotland in regard to inspections, and we don't want to encourage any further auditing. We don't want to encourage bad practice, certainly not, but we want to make sure that everyone is safe, happy, and we can just get on with our day jobs. So, what are the proposed changes? What I'm going to do is give an overview of the changes and then dig into a couple of them in more detail, the ones that are really relevant or the ones that I feel will have the most impact within the agri industry. Ban on exploitative 0-hour contracts. So all workers must have guaranteed hours and a contract that reflects the reality of their working hours. Enhancement to the gig economy rules. So it's not something we have to worry about in agriculture. Essentially, the changes look to establish more individuals as workers rather than self-employed. Gig economy examples being Uber. Similar to what happened with IR35 several years ago, and the sudden focus on the question, is this individual genuinely self-employed, or is this individual actually employed and we are falsifying the worker status? That question is important on agri sites, certainly, and something I'll talk about when we get to contracts. Enhancement to trade union rights. We're not really going to focus on this too heavily, as Unite the Union has 6 individuals sitting on the Agricultural Wages Board for Scotland. So they're already around in the sector. The aim generally is to allow the union easier access to workplaces to recruit and support members. That's the general aims. Enhancement to parental rights. So parental rights cover everything from maternity, paternity, adoption, all the way to neonatal care, carers leave, etc. There are improvements to maternity protection. The aim is to promote better protection for employees when returning from periods of family leave. There are also discussions to provide enhanced bereavement leave for all workers, as well as some more proposals in the work a bit further down the line. Protection against, well, strengthen protection against unfair dismissals. As you may know, and as we'll discuss, unfair dismissals are a claim that can be raised at employment tribunal. Alongside this, in the strengthening protections of that, the fire and rehire practices will be banned, and the claim window for unfair dismissal will be changed. The right to disconnect, I will explain a little bit, well, actually I will explain a lot more about this one, is a proposed new right, allowing workers to disconnect from work communications outside of normal hours of work. And fair pay for all age groups. The proposal is looking to remove the age bands in minimum wages, so all workers will receive the living wage. So, doesn't really mean much when I just list it off like that, does it? Let's have a look at a couple of these in more detail, and hopefully they'll make a bit more sense than just that list. First off, let's have a look at day one rights. Day one rights are what rights that an employee gets as soon as they start working for your business. So that first day of employment, these are the rights they get. So what do they currently have? National minimum wage, 28 days annual leave, or 20 plus 8. That's the statutory one. So for in Agri, that would be for a 5-day working week. Obviously, we know AWO requires different holiday entitlements depending on how many days they work on average. Protection from discrimination. So pretty simple one, that. Right to request flexible working is a day one right. It's been a day one right since April 2024. An employment contract, which has details of probationary period, hours of work, etc., and access to certain policies and rights of employment. So family leave, disciplinary and grievance processes, preventing sexual harassment in the workplace. I will do a quick sideways step, as you will find I will do throughout. Preventing sexual harassment in the workplace is an interesting one, and I don't focus on it anywhere else in the presentation. It became a duty, a burden to the employer. I was debating this with Mari. I'm certain it was in 2024, but I'd have to check my emails. I know it came in place in October. It essentially requires the employer to proactively train their team, old and new, on sexual harassment, understanding what it is, identifying it, and how to protect against it. This is something that I found a number of my own clients didn't see our communication about when it came into law. And I found a number of clients haven't really, a number of businesses haven't really heard about it or understood what it requires. The watchdog will be looking for things like this. ACAS, I will put a link to ACAS later on in the slide deck, is employment law best practice. It has a policy, it offers training. Something to be very aware of is that there is a proactive duty on the employer to provide training. And it's the first time preventing sexual harassment in the workplace. It's the first time we've really had that burden on the employer. I think we will see more of that going forward. So it's certainly worth being aware of. Now, what are they looking to change? What are the updated rights from the first day of employment? On top of everything else, sick pay from the first day of absence. Now, that's statutory sick pay. We will look at this in more detail, and I will compare out how agricultural sits as well. But statutory sick pay from the first day of absence, that's currently paid from day 4 of absence. The genuine living wage, maternity and paternity pay from day 1, both of which have eligibility criteria so far. Enhanced bereavement leave, it will be 1 week. Agricultural wages demands 3 days, but it will go to 1 week. The right to raise unfair dismissal claims. This is the biggest piece. So I jumped that really quickly, sorry. So what I would like to do, these are the ones I'm really going to focus on tonight. And we're going to just go through one at a time and actually just see what those changes mean and how they really impact an employer and what kind of things you have to be aware of. So the first thing is, and you know it's got to happen when you've got an HR person holding a webinar. I want to talk a little bit about contracts. Agriculture is renowned for not loving lots of formal paperwork, and every day I come across a site that doesn't have contracts. It is what it is. I don't hold it against you. It's a historic thing. We're trying to encourage better practice, and certainly it's something I'll talk about. So what is a 0 hours contract? What do they mean by exploitative? A 0 hours contract essentially means the worker has no guaranteed hours or days. The worker has more flexibility with their working hours, but has no guaranteed 2 hours. And the employer has a more flexible resource pool, but no guarantee that workers will be available when they are needed. The bill itself contains 11 pages about this contract so far. And yet it still says that more details will be published in due course. Several years ago, and you may have heard of the drama at the time, fast food chains, I think McDonald's in particular, caused a massive issue with this contract type. The benefit of the contract is that it gives you the status of a worker with the attached benefits, holiday, sickness, etc., but allows you to take up hours flexibly when you wish. The employer simply offers hours, the employee gets to accept or reject them at their peril. Where it got messy is what the fast food chains tried to do was put restrictions in the contract, basically stating that the employee couldn't work anywhere else. And you can't do that. We're not allowed to restrict an employee's right to earn. I personally, if used correctly, quite like this contract. I think it offers a really flexible option. And the problem that came about was that people felt they were being the political sphere, felt that employers were forcing 0 hours contracts onto employees against their will, and that it was all the power dynamic was all with the employer. Part of the removal of these 0 hours contracts is to rebalance the power dynamic. I do come across sites where, and this would fall under the exploitative heading, a worker genuinely works 40 hours a week religiously every week, but their contract says 0. So when it comes to notice, when it comes to holiday, all of these benefits of employment, well, notice isn't a benefit, benefits of employment are impacted by the normal hours of work. If someone's genuinely working 40 hours and we're paying for that, that should be reflected in the contract. If they've been working it for over 52 weeks, that should be genuinely reflected in the contract. That's what the exploitative piece means, that we as employers are not giving the employees, genuine employees, benefit of the doubt when they're working a set amount of hours, and we really don't see fluctuation with that. These contracts typically are used on seasonal sites, or I see more of them on seasonal sites. The impact of this will hit seasonal sites more. However, I'm sure you all have seasonal natures, highs and lows, whether it's harvest, lambing, calving. And as you take on additional workforce during those periods, this is maybe an agreement that you use. The ban is something to bear in mind. We changed all our clients, bar one, who wanted to stay with this contract type until they were forcibly told to take it out, to minimum hours contracts. So we guarantee the worker a minimum 8 hours a week, a 1 shift a week. Or if we know that we know they are religious 40-hour a week workers, we guarantee them more. So you can change to that. That's not a difficult contract type to use. You can change to minimum hours. You could change to average hours. You could change to temporary contracts. Some clients I've worked with have 6-month temporary contracts just to cover the seasonal peak. That works really well. If the ban goes into place as is proposed, the alternative that Labour has put forward is a guaranteed hours contract. It will be based on a 12-week reference period. So whatever they work, an employee works on average over 12 weeks, those become their guaranteed hours. Now, let's bear in mind, if some of you are going through lambing and calving, we know those hours go over really 60 a week. That reference period could suddenly look huge and not be reflective of what your business actually does across the year. That's why I personally love average hours contracts, because we can build that kind of thing in. What essentially the rules are going to be are: don't take the mick as an employer, balance it out fairly so the employer has a reflection of their working hours and what that looks like. If you are a seasonal fruit, veg producer and you are provided labour through one of the licensed suppliers, it's likely that that provider has already demanded that you have a certain number of minimum hours in the contract. Certainly in the seasonal fruit farms I work with, the minimum hours have to be 32 a week. So you may already have that pressure from the provider. This is where it's coming from. It's all coming from these guaranteed hours, the guaranteed hours piece. The main things that the proposal is looking to do is to guarantee hours, to provide reasonable notice of working hours and cancellation of hours, should that be the case, and acknowledging that those hours the employee is working are a genuine reflection of their week-to-week process. It can sound complex. It's really not on paper, certainly not within the contract. The options available, minimum hours, average hours, or the guaranteed hours model, are all really usable formats. They won't massively change your process at this stage, but it is something to consider going forward. We don't have go live dates for everything. They will be within the next 12 to 18 months, but having some preparation or changing how you're doing things now will only benefit you later because you'll be ready and there will be no catching up. As we know, sometimes things come into law, and because it's not our day to day, we can overlook it. It just kind of bypasses us, and then the auditors come out. So certainly, considering this early is always better. And as I said, oh, I've seen Mari up here.
Sorry, I was just going to pop in a little question.
Go for
Um,
it.
just coming back to the first point on not always things are written down on paper. Obviously, here,
Mm,
we're talking 0 hours contract, but should we
mm,
also be thinking of arrangements that maybe are in, somebody doesn't consider themselves to have somebody on a 0 hour contract, but maybe the likes of
mhm.
like relief milkers and dairy sectors, they will quite often be just called upon when needed.
Yeah.
So that's this situation, even if somebody doesn't consider themselves to have somebody on a 0 hours.
What a perfect time for me to segue into contract chat. Yeah. So yeah, as I told you, if you come on an HR webinar, you're going to get some chat about contracts. Yes. Okay. Good question. Whatever the arrangement that you have, even if it's with a relief worker, the reality is that what you have, if you don't have paperwork right now, is a verbal agreement, it's a verbal contract. That doesn't mean a lot in law, and it's certainly not the rule. But that's what it means. So a relief milker, let's take it as an example, a relief milker, you are calling on ad hoc. What you would actually have in place there is a casual worker contract, the terms of which are quite interesting. It basically means then they're a worker, they're not a full employee, their benefits are slightly different in that regard, but it allows you to offer them projects, chunks of work when the work becomes available, which they can accept or reject at their leisure. A contract type is still a requirement. It's actually a day one requirement, regardless, across the board, day one requirement for everyone working with you. Um, the beauty of a casual worker contract, unlike an employment contract, is it kind of sits in the background. You agree it with a person, you're going to be a relief milker, you're going to come to this particular dairy site. Let's assume you have one particular dairy site and not multiple. You're going to come to this particular dairy site. You're going to support with milking the herd. And this is kind of what the hours look like. This is the rate of pay I will pay you. And I will contact you if and when hours come up and you can accept or reject them. And the contract just sits there in the background, ticking away. I have them with automatic termination clauses. So if we haven't offered someone work or they haven't accepted work in a period of 6 months, let's say, the contract will naturally terminate, naturally go away. That means no notice payments, none of the fussy, difficult stuff of terminating an employment contract. So, in answer, you should have a contract in place regardless of the relationship. But there are slightly different versions available for particular jobs, such as a relief milker. And as I said, it's a perfect time for me just to quickly segue into contracts. I spoke about a lot of contracts there. I will stop speaking about them so much as we go forward, but I spoke about a lot of different types of contract. As I said before, agri-industry is 50-50 when I talk to someone if they're going to have contracts or not. If you don't, and you don't want to have someone like me draft them, Agricultural Wages Board has a relatively good template available. Even if you put that in place, that'll protect you when Agricultural Wages comes and does an audit, because it's their own documentation. A lot of agreements are made verbally. That's been the history. It's a shake of the hand, nod of the head, sometimes a text message. It isn't the legal position, hasn't been the legal position for some time. And as we continue to move forward in this new political climate, there'll be more eyes on employers. There's always eyes on employers, but there will be more. And if that watchdog is released with as many teeth as they're saying it will have, then we want to ensure that everyone's just meeting their statutory duties. The beauty with a contract is that it's a tick in the box. It's one document that you have to have a template for. As you get a new employer in, a new employee in, you go, here you go, these are your terms and conditions of employment. Sign, date, put on a file, leave it on that file. It's not going to do anything. It's just in the background, evidencing that as the employer, you've informed them of their rights, of their notice period, of their holiday entitlements, that you take data processing seriously and legally, that you take criminal activity seriously, and that you will be terminating contract if there's criminal activity, that you do not accept smoking, that you run CCTV on your site, that you have health and safety policies in place, that you have biosecurity in place if you are an egg producer. It just clarifies all the bits and pieces. We all have those documents at home. In reality, we have them for our houses, we have them, God forbid, for the houses, because they're very long documents, but we have them with everybody. And it's a one-stop shop just to go and go, here you go. That's our agreement with you. That's what we will do as an employer, and that's what you are due to do as an employee. And if either party breaches, then there's evidence of that. Where we get into sticky water is when someone turns around. It's always sticky water. It's something I can get out of. But if someone turns around and says, I want to get rid of that person, don't like them anymore, they general farm worker, fell out with my herd manager, had a big brawling match, one of the questions I'm going to ask is, do you have a contract? And if it's a no, then I have to refer to the default grounds. If it's all gone nasty and I have to do a settlement agreement, that has to go to a solicitor. Contract is something they're going to ask for. If someone goes to citizens' advice, they're going to ask the employee, where's your contract? It will save a lot of bother to have the piece of paper up front. Okay, I'll move on from contracts. I'm well aware I can get excited about contracts. What I will cover, yes, Mari.
Sorry, just another question before we move on to the next section. 0 hours, questions come in. How does 0 hours affect on-farm contractors?
Oh, beautiful on-farm contract. Thank you, whoever asked that, because you've reminded me. Oh, another contract. Sorry, we're going back. On-farm contractors, otherwise termed as self-employed individuals or contractors generally, it doesn't impact them. They operate under what is known as a contract for services, which is uniquely different from an employment contract. They are self-employed. They handle their own tax. They handle their own national insurance. We pay them gross. There's other details. They, the right to terminate, the right to use other people, except there's all sorts of sub-clauses to a contract for services. But essentially, you make an agreement with a contractor to do a certain project, carry out a certain task, give you a certain service. within that agreement, you may agree a certain amount of hours. 50-50 whether that happens or not. If you agree a certain amount of hours, and you say, okay, well, you're going to be, let's say they're providing some sort of mechanical support to the site, and you agree contract services, they're going to provide mechanical support for the site, and you agree that they're going to be on your site 1 day a week. That's fine. If you agree that they're going to provide mechanical support for the site and it's an ad hoc, called as and when, and this is the rate of pay, absolutely fine. The hours don't impact them because they're self-employed. They have one of the unique abilities they have is they can work wherever they want, for whoever they want, whenever they want, without your permission. They are contractors. So it doesn't impact them. However, there is a contract type, of course there is, contract type available that I heavily recommend is used with contractors. Again, it's a minimizing risk security thing, that if we have a piece of paper that stipulates we're not your employer, we're your principal, we are the principal, and we are contracting you to do this job for this amount of money, and you have the right to replace yourself if you're unavailable to do the work, you have the right to do this, the right to do that. Again, it's stipulating whose duties are what, whose rights are what, and it keeps us in the right. It keeps us really clean and clear. One of the things the watchdog will be looking for, reality, is they will be looking to identify whether individuals are genuinely employees or genuinely contractors. We find a lot of sites have had a history of using contractors, farm contractors. It's how they'll refer to people. They'll say, oh, well, they're self-employed, but they're not. They don't pass the test because they only work on your site. They don't give you invoicing. You process them through PAYE. So there's a number of tests, and that is again something they will be looking for. Even if the person doesn't have an issue with the agreement, it's something you as an employer have a duty to get right. And even if the individual doesn't want to do anything because the agreement works for them, the watchdog could punish you financially for it. So again, just something to bear in mind. And as I said, I know this bit is complex and it feels complex as I'm talking about it. It's not for our day-to-day, and individual circumstances, we can certainly discuss those to try and help you figure out what's going on. Okay, probationary periods, something that isn't on the day one lists. You will have heard about them before. They cover the first 3 to 6 months of employment. They have been called trial periods. I think that's a bit misleading, but that is essentially what they are. They allow the employer to monitor conduct and performance to ensure the person is fit for their role and for the business. Vice versa, it allows the individual to decide whether they like working for the business. It can be extended if issues arise, to encourage improvement while still having protection in place for the business. Extension, however, is a one and done option and can only be for the safe period. And during this period, notice periods are limited, 1 week, both parties, which makes termination less painful if we have to do it. So the reason I want to talk about probation periods really quickly is that a lot of people miss them. They just kind of don't have them in a contract, or they don't talk about them, where actually they're really critical, and going forward they will be more so. The change within the Employment Rights Bill, bit that's impacting these. As I said, it covers the first 3 to 6 months of employment. I generally see, for most jobs, 3 months. For managerial jobs, supervisory, higher up in the hierarchy, 6 months. And what happens during that period is you have the opportunity to monitor the employee's behavior, their conduct, their performance, their attendance, to make sure they're the right fit for you. We have more legal protection in the probationary period as well. We have less process to do if something's not working. It's much easier to get rid of someone. And my recommendation is always to actively use these periods, because actually within the first 3 to 6 months of employment, you started to see the real person. That shine wears off within the first couple of months. But if issues are coming up, you have the ability to extend that period. The change, normally we could have extended it for up to 12 months maximum. The change in the bill is that 9 months will be the new legal limit, or the new safe limit. So if you start off with a probation period of 3 months, you could extend by 6. I've said it's not normal. We normally see a like for like 3 months extension, 3 months, but technically that you could do that. As I said, it's a one and done option to extend those, so don't think that that's something you can keep going forever. The protection that you get under probationary period is that there's less a process. You are under a duty to give fair notice of issues to the employee. So they know something's gone wrong, and you should allow them some time to improve. And when I say some time, in law is, well, not in law, in case law, you see it coming in about a month, unless then there's nuances to that, but it's normally about a month to improve. You also have to just provide that in writing as well. They should have a letter, an email at least, that says we're extending and this is why. For your business, minimizing risk, looking at it from that point of view, documentation is always your friend in terms of agreements you make, conversations you have. When it comes to things like probationary period, we want to be able to turn around and say, well, actually, we did give the employee, we're always protecting against the third party, the unknown third party. We did give the employee fair notice that there were issues with their performance, that they weren't able to do this job properly, or they were constantly missing this particular task, or they are coming in for work late. They're late every day by 5 minutes. Or a recent client I spoke to, the person had been working on the site for 4 months. They've been ill once a week since they started, but they've not been phoning in and reporting sickness. They have just not shown up to work. And along with that, they've not only not shown up to work, they have then not explained to the farm manager what's happening. We've only found out latterly that, they had a dentist appointment, so they took the whole day off. They had to take their dog to the vet. They had the whole day off. They had to help their grandma do something. They had the whole day off. In the probationary period, we can turn around immediately and say, which we should do anyways, but turn around immediately and say, this is unacceptable. This is the expectation. And if you fail to achieve it, you will fail your probationary period. Simple as that. Cut, dry. It's a really useful thing to use. It's something I recommend using all the time. And going forward, that 9-month safe window will be the only additional protection we get from unfair dismissal claims. And that's the critical point. It protects against one particular claim at tribunal, which is seeing a major shift as well.
Sorry, Sophie, just going to jump in with another
Don't worry.
question. It mentioned giving notice there, but a question in
Mm.
what does that look like? Is that verbal chat or would that need to go into writing to give
Oh,
notice
you
to
know the
the
answer to that. Technically giving notice. So however you give notice, whether we're looking at it within the probationary period, I will just do a segue on notice, I think, in a minute. If it's in the probationary period, you will have a verbal chat. You will have a formal verbal chat. That means not a walk and talk, informal, in the hen house job, which is, I know, the standard day to day because we're working and moving. These conversations will be formal, i.e., you will take the time, 20 minutes, 30 minutes, to go and sit down with the person, take them out of take them out of the shed, take them out of the dairy parlour, to sit down and say, this is the issue and this is what we're doing. If you have to give notice on probationary period, there are two options. You can either do the fair notice piece, give them fair notice of the issues, give them time to improve. If it doesn't work, give them notice. And that is a conversation saying, Jim, we had a conversation last month about your attendance, and actually it's not improved. You're still not following sickness procedures. You have had 2 more days of unauthorized absence to go to the doctor, to go to the podiatrist, whatever it is. It's not acceptable. We gave you notice of the issue. You haven't improved it. It's really simple procedure. So unfortunately, you failed your probationary period. And as per your contract, you have 1 week's notice. We are putting you on notice from today. Now, the trick with notice, you can make someone work it or not work it. Sometimes in these instances, not working it's just so much easier for you and for the site and to move things forward. And you can do what's called paying notice in lieu, which basically means if I had a conversation with Jim today and said, that's it, you're done, done, then I'd say, right, today's your last day. You don't have to come back. You're due 1 week's notice by contract. We will pay you for it. But today is your last day. So that's a really great way of dealing with notice. You have that as a verbal conversation, but then you follow it up in writing. And in writing, because the writing is your evidence to that unknown third party, that citizen's advice person sitting behind the employee, it's your evidence to say you are doing the statutory duties. And the letter only has to say, following our conversation as of, I don't know what the date is, let's say it's 20th. Following our conversations on the 20th of June 2025, we reviewed your attendance following our previous conversation. Unfortunately, you have had 2 further days absence, and as such, you have failed your probationary period. As per your contract, you're due 1 week's notice. This will be paid in lieu on such and such a date. You will be paid for any further working hours. It depends when your payment schedule runs. This is how many holidays you've accrued, whether you owe us or we owe you. And before you leave, make sure you leave any keys, documents, fobs, anything like that with us. It's not a big letter. And it's as much as just confirming that you understand that they are due notice, they're due any working hours that they've had and not been paid up to date, and they're due holiday that they've accrued and not yet taken. So again, it's just your evidence trail. Doesn't have to be a big thing. And you can have a template sitting. I have a template sitting for when my clients need it. So yes, always formal in writing. Okay, just before I give you a break, let brains reset, I do want to talk about probably the biggest piece, the most impactful piece that we're going to see, and that's going to be across the board. That's going to be with every employer across every industry. Unfair dismissal. Unfair dismissal is quite frequently misunderstood, I've found, when I've been speaking to people. So people will tell me they understand that they're protected under 2 years. If someone hasn't worked for them for 2 years, then they can just get rid of them, right? No issue. They can just terminate them willy-nilly. Bit of a misunderstanding. The 2-year window is for the right to raise an unfair dismissal claim at tribunal. The window has been in place since 2012. So we've had it for quite some time, and I think it has been successful because we are prepared to see quite a spike of claims when it's changed. Essentially, what it means is that if we need to terminate someone and they've been working with us for under 2 years, if we mess up the process a bit, so we maybe don't have as many conversations as we should do, we maybe don't give out the formal letters, we maybe don't have a sit-down conversation, it may have been a blow-up between this individual and the farm manager director, and we just said to the person to get off site immediately. If we mess up the process, and I say mess up as in we are not aligned with ACAS, If we mess up the process somewhere, the 2-year window has been in place to protect employers against unfair dismissal claims. What is unfair dismissal? Basically means that we have dismissed without following fair and reasonable process. The proposal is to change it. The current political party feels that this gives employers too much protection and that employees should have the right to raise an unfair dismissal claim from day one of their employment, with the sideways comment that 9 months of probationary period will see some protection for the employer still. It will not be fully taken out. Unfair dismissal is just one of the claims. In reality, there are a number of claims people can raise from day one already. So I don't want there to be some thought that this particular claim is going to be the be all and end all. It's not. The most claims we see, the most claims the tribunals are seeing at the moment are discrimination claims. Those are day one claims. That's discrimination, harassment, etc. There is also automatic claims that can go to tribunal, health and safety issues, whistleblowing issues, etc. And there's also wrongful dismissal, which is a day one right, which basically means that the employer has breached the terms and conditions of employment to the point that there's been a dismissal. So there are loads and loads of claims. This one just happens to be the one people, even HR, the one we sort of get the most upset about, because it's quite a challenging claim. That's just the reality of it. When the 2-year time frame has changed before, and this is legal speak, but when it's changed before, the government changed it by a statutory instrument, which meant that it was easier to change. It was a faster method of changing it. What Labour is proposing they do is change it by statute this time, which means changing it in an act. The reason being, it is not impossible, but it makes it so much harder to change it back. So if, for example, Labour were to lose their seat and Conservative came back in, they couldn't immediately reverse it. It wouldn't be possible, where previously it's been possible. That's being taken away. So once this goes into an act, we're to a certain extent stuck with it. And what it would mean is that any failure in process that resulted in a dismissal, the employee would have the right to raise this claim at tribunal from day one. And the process of that claim, for example, doesn't actually cost the employee anything at this stage. They start by just going to ACAS for reconciliation, which basically means they go to ACAS with a complaint and they say, I was unfairly dismissed for these reasons. And ACAS don't judge the reason. They will then act as the go-between between the parties. Hopefully some of you have never experienced this and will never experience this. They act as the go-between between the parties, and they come to you as the employer and they go, Bill says he was unfairly dismissed. We have no judgment of that, but Bill is going to raise a claim unless we can negotiate payment here and now. You have options as an employer. You can negotiate payment. You can knuckle it out and go to tribunal, or you can knuckle it out and try and negotiate on the way to tribunal, which is what most people do. If Bill decides to go to ACAS, it's not much. Honestly, it's not much pressure on Bill. He can go to ACAS and start the process. The burden of evidential proof lies with the employer. You have to prove that Bill was an employee, that Bill did something wrong that required a dismissal, that you followed due process, and that means notes, written warnings, sanctions, evidence, CCTV, anything you've got has to go forward. Some of you may have gone through insurance claims for things in your personal life or within your business. That level of evidence that is required for a tribunal. And it's primarily on the employer. really is. So this isn't something we just don't want to tangle with unfair dismissal, because essentially as soon as someone enters ACAS, you're either going to be getting out of it by paying, negotiating a settlement agreement, by going all the way to tribunal and, in reality, hoping you win. Or we had a recent example, and I mean, this was a corker. An ex-employee raised a tribunal claim, unfair dismissal, with one of our clients. The individual in question had been made redundant. Fair redundancy was one of a handful that was made redundant. They decided to raise a claim because they didn't agree. They felt that something else could have been done. They went to ACAS and the employer said, no, I'm not settling. We did the right thing. That employee held them to the tribunal, held them all the way. The employer wasn't going to negotiate and agree a settlement. They knew they'd done the right thing. The employee held them all the way up to the tribunal date. And then, only then, did they pull out. And generally, that window is about 6 months. So for 6 months, that employer thought, oh my God, we're going to go to tribunal. And as much as we believe we've done the right thing, the tribunal can award compensatory awards, loss of earning awards. They can do that just on the basis of the person's argument and feeling towards it. And obviously, that all comes at a cost. It comes to the cost of hopefully your employers, hopefully your insurance. But it depends. These people had a not a great insurance deal, and the excess was £10,000. So they were going to have to potentially pay £10,000. And actually, up until this employee pulled out, I think they are due 7,000 to date. And that's just for talking to their solicitor, getting their solicitor to interact with the tribunal. So this isn't something we really want to have any employers dealing with just because they're not fully aware of what they should be doing. I'll just quickly flick this onto the screen because I want to say that's the link, ACAS. I've mentioned ACAS. It is best practice. You may have your own policies on site. Absolutely fine. If you have your own disciplinary grievance policies, etc. on site, fine. ACAS is the code of best practice. If you don't have your own policies, go to them for everything. They're really easy to read. They're accessible for the employee as well. So it's really transparent how you're going to handle things. If you need to get rid of someone, you will need to have a process. I'm going to speak a lot about process, but I mean performance management. If there are performance failures, we should see performance management. If there are conduct failures, we should see disciplinary management. We should see sanctions. If it is attendance, same thing. We should be seeing some follow-up, some sanctions to it, because your word, when it comes to tribunal, your word is not good enough. It needs to have been in writing. There needs to be an evidence trail. And that's part of what due process is going to be. And it's what can actually happen when it gets to tribunal. Even if you can evidence bits and pieces and you can go through and the tribunal has swayed in your favor, they can still offer compensatory awards on the basis that you've missed something. You, in a redundancy situation, didn't consider alternative employment. Compensatory award, up to 25% compensatory award. You didn't actually issue out formal sanctions. You had the conversation. There's some dialogue, whether it be on WhatsApp or Messenger, etc., that you can evidence it happened, but you didn't issue the sanctions. You didn't give the right of appeal. You didn't give them the right to an accompanying person during that meeting. These things are little blips that could just cause trip ups. So all we're trying to do is say, right, be aware it's coming. Don't hide your head in the sand with this one, because actually as soon as it becomes a day one right, it's going to be much more difficult to move people. So we want to be able to say, okay, if you come to me tomorrow and say, I need to get rid of this guy, and I say, what have you done so far? Actually, you can say, well, I need to get rid of this guy. And I say, what have you done so far? We had informal conversation. No, actually, we have had this sit down, and I sent this email, and I've evidenced it in this way. And I'll go, great. Okay, so let's just clean that up a little bit, and I can get rid of them, and this is how we're going to do it. That's it. That's what we're asking for. It's not screeds of paper. It's just protecting your own back. And it builds a picture of why you want to get rid of someone if that be the case. I mentioned that there's other loads of other claims that people can do. Unfair dismissal there are, as I said, automatic ways to get into tribunal. So you can say that you were unfairly dismissed if, for example, you spoke about health and safety. That's an automatic reason. You were dismissed because of this, or you raised a whistleblowing claim. There are things that are automatics. Unfair dismissal will only be a right to raise a claim from day one of employment, that it doesn't apply beforehand, with the exception if you've offered someone a job, and this happens more often than agri than we would like to think. If you offer a job, I would love it in writing. Obviously, I would. If you offer someone a job, generally, what are you doing? Shake of the hand. These are the hours. This is the job. This is the pay, etc. But then you speak to Neil down the road who employed them several years ago, and they go, "Oh, avoid that person. Avoid them like the plague. They've got this issue, that issue. Attendance is rubbish. They might come across great in the interview, but they've got really bad attitude." All of those things. All those things we hear in informal references, and you go, "Oh, actually, no, I don't want to take the risk on this," and you rescind the offer. You turn around to them and say, "Sorry, mate, don't want you anymore. I had a reference really bad. Don't want you on site." If you rescind an offer for an informal reference for something that you haven't specified within the offer letters should have, these are your terms, subject to proof of right to work, 2 references. So a lot of you require driver's licenses, proof of driving license, criminal checks. Some will need them, some will not. Tickets for certain machinery, etc. Things that if you are asking for them and they're saying they have them, they should be able to prove them. That's your offers should always be subject to in that regard. If you rescind the offer and haven't told someone that it can be rescinded if they fail on some of these criteria, then it's an automatic claim to tribunal, even before they've started employment. So this, again, it's a process thing. It's just doing that little letter. Again, it's a template, really easy to do. Flexible working. You've heard of this. This is not new. Became a day one right in April 2024. Did it make a difference to the businesses? Probably not, because most people didn't really pick up on it. We've always had, the employees have always had the right to request flexible working. It just wasn't a thing years ago. It's become more of a thing recently. You have a lot of chat about it on social media. Some of you may have heard, and I will say this correctly, I know what it sounds like though, Mother Pucker. You may have heard of her stuff on Instagram. Some of my clients were the first to tell me about her. Very much promotes flexible working and flexibly working. So there's a lot of chat about it, a lot of challenge about it. It became a day one right in April 2024. A couple of changes happened at that time. Previously you could only apply for it once a year. Now you can apply for a flexible work. You can put 2 flexible working requests in per year. And actually, did I see a massive uptake even in my client pool, and who were dreading it, by the way, when I sent them the new policies? I did not see a massive uptake. People were quite happy. People were quite happy doing their thing. Where I see it a lot, let's be honest, is return from maternities and things. So what enhancements are we going to see? Actually, you know what? Let's talk about what we dread. What kind of flexible working requests could we receive? Let's rip the plaster off on this one. So it's a day one right already. You could have recruited someone for a 5-day-a-week job. Let's go with something, farm secretary, something like that, an admin-based role. Let's go with that one because it's just slightly easier to talk about. You could have recruited someone. You needed someone full time, 5 days a week, 9 to 5. That's what you needed. That's what you recruited for. Joe Bloggs starts on day one and they put in a flexible working request. That is their right. And what could Joe be asking for? Well, Joe doesn't want to work in the office 5 days a week. They want working from home. They don't actually want to work 5 days a week. They want to work 3 days a week. On farms, okay, let's look at a dairy operative, someone who works in our dairy parlors. They don't like working 7 days a week. They don't like the way our rota works. If we have a rota, they want 5 on 2 off. Those are genuine flexible working requests that could happen. And what duty are we under? Try and agree it. That is the duty. Now, the duty is to try and agree it. It's to be reasonable. If someone asks something unreasonable, we do not have to agree it, but we do have to follow a process. There are 8 legal reasons we can refuse a request. They're on ACAS. They're things like customer detriment, inability to redistribute the workload, too much money to recruit or employ somebody else. There are 8 reasons. If you're ever going to refuse flexible working, for God's sake, please pick at least 3 out of the 8, not just one. They actually all tie in together anyways, so you should be able to see a through route. There was an initial concern they were going to change those. So far, or weaken them at least. So far, they haven't. They've said they're going to leave the 8 legal reasons alone. However, there is a duty for the employer to explain in more detail why they are refusing a request and for what reason. So, what does that actually mean? If someone hands you a flexible working request tomorrow, always get it in writing because that's part of the process. You have a duty to meet with the employee. What I recommend is that you receive a flexible working request. That's step 1. Step 2, have a meeting with the employee to discuss. You cannot ask them why they want flexibility, but you can say, thanks, Joe, got your flexibility request. Even if in your head you're going, absolutely no way, there's no way I can do this. Your job is to go through the process and to look for options. That's the job. So you say, thanks, Joe, got your flexibility request. You want to work 3 days a week from home. Obviously, I have 2 months to respond to this request, consider and respond to it. And in that time, Joe's still got to work their normal shifts. But to help me initially, and we've said this, actually, I'm going to give you, you know what, let's can Joe for a minute. I've got a live example of where this happened recently. As I said, a lot of these requests come in after maternity leave or return from long periods of leave, either sickness, sabbatical, etc. I had a client, an individual, was returning from maternity leave, 52 weeks of maternity leave, and they put in a flexibility request. Not unheard of, fairly common. They worked 5 days a week, 9 to 5 in an office. They wanted to work. Their first option was they wanted to work 3 days a week, part-time, 10 till 3. Or alternatively, they would work 2 full-time days. But they could not work Fridays because they didn't have childcare cover. They were not considering nursery. And we figured it out that actually they only wanted to work under 16 hours so they could get the child benefits. So the employer phoned me and said, we can't do this. We can't do it. It's just not feasible. The office that they're in has, for the role that this person does, there's only 3 of them. 1 full-timer, this person was full-time, and we have a part-timer already. I said, right, okay, that's cool. Okay, it's fine. Your initial reaction is no. Right. The next part of the job is to meet with the person. And so they had a meeting and said, right, okay, thank you very much for your flexibility request. Initially, this is quite a large request, going from 5 days to 2 or 3 part-times. We need to be able to consider it fully, but we also need to know what other options we have. We need to have everything on the table so that we can go away and consider this properly. Are there any particular days you cannot work or don't want to work? This person said, she said Friday, can't work Friday. My partner works on the rigs, can't work Friday, inconsistent childcare. And they said, okay, well, Friday is a peak customer trade day for us. Mondays and Fridays are the peak days. So that's going to be a challenge. Could you work every second Friday? And they did this. They just explored, asked lots of questions. Why were the part-time days her preference? Was it because she was doing pickup drop-offs? Where was that coming from? Could she work the 9 to 5 full-time day? And certain things came out like, no, she would always be 10 minutes late because of where she had to do drop-offs, etc. Okay. So I have a conversation with the employer following this meeting, and they go, oh my God, this is what she said. She said all of these things. And I go, right, well, what can you do? Because that's a duty. The duty is to try and agree something. What can you do? Obviously, you're telling me you're saying no to the original request. Let's discuss what legal reasons fit with that. Why are we saying no? Well, we couldn't redistribute the workload. There would be significant customer detriment. And I think we picked another, I think actually there was about 4 reasons, all that came together. Right, so we've got clear reasons and explanations of why we can't do the original request. She's given us all these alternatives. What's the best thing to do in those instances, if you're going to deny flexibility or a flexible working request, is go back with what you can do. So they could offer 3 full-time days a week, Monday, Wednesday, Friday, I think it was. And we had a big debate about Friday and said, well, she's already said this, but now in the meeting, she said you might consider looking at nurseries, etc. Okay, well, if that's what you need, operationally, that's what you could achieve, then we wrote back to the individual and said, we'd already confirmed in the meeting, we probably wouldn't be able to do the initial request. So we'd actually met that duty. But we wrote back to the individual and said, okay, thank you for your request. We can't do your original one for all these reasons, legal reason, 1, 2, 3, 4 explanations. However, we've looked at the options we have available and we could offer this to you. It then came down to the employee to accept or reject it. It turned out latterly that she came back and she said, really, actually, thank you very much for explaining in so much detail. There, we're protecting against the third party reading it. So we've been super clear what we've considered and why we've done it. But actually, that just doesn't work for her, and she's resigning. Okay, that is absolutely her prerogative, and it's a shame. We didn't really want to lose her, but if we can't meet the flexibility criteria, then that is the reality. Some people will say, she happened to say no, and actually, I'm going to proactively resign. Some people will say no, and we'll go, okay, well, then you're going to continue working full time, and they'll appeal it. Some people will say, yes, I'll take that. I once had a guy that I worked for my team, and he said it was 5 part-time days a week. I believe it was like 5 days, 4 hours a day, something like that. And he said he wanted to drop a day, and I said, I can't do that because I can't recruit someone for that missing gap of 1 day. What I can offer you is 3 part-time days a week. Bit my arm off for it. Didn't even know that was an option. I was delighted. So it's all about options. The duties that you have under flexible working are to have the meetings, the follow up in writing, and use the legal reasons if required. And as I said, it's all about that. Again, that one is all about paperwork. The one tray, yes, Mari.
Sorry, I feel like I
No,
I
apologize.
never get my camera off quick enough. I always disrupt your flow. So 2 questions here. First off, the sort of 2 requests per year, is that
Mhm.
almost that they can request 2 different aspects of flexibility that then run like together, or is it almost the second request can be to change the first one? I don't know if that makes sense.
Yeah, no, that makes sense. To be fair, technically both. So Joe Blogs could start the year saying, well, actually, I only want to work 3 days. And you go through a whole shebang process and you agree it. And then 6 months and he sends another request. He wants to work 2 days, or he wants to work from home, or actually wants to go back up to 4 days. One can overwrite the other, or they can work in tandem. So Joe could have said 3 days, you've agreed that. Then he comes in with another request saying, well, I want one of my 3 days work from home. And then they would combine. So I have to say, I don't tend to see people raising multiple requests in a year. If we are dealing with this in the right way and having the right dialogues, then we're pretty much making ourselves abundantly clear what we can do, because it's down to our operation and we can't positively discriminate. We can't change our operation for one person. They have to fit in with what we can achieve. So I tend to just see the one, and then sometimes you'll see an appeal process, but that's rarer.
Okay. And just on you mentioned there what you do see. Have you seen any sort of changes in the dynamic of who's putting in requests, or from what type of employees? Any
Yeah.
changes like that that would be of interest to the audience?
Yeah, as I said, the majority of the requests that I see, they do come after maternity. I think that would be probably all sectors, because there's suddenly such a change in the individual's personal life that there needs to be a flex in working life. I have seen there's no particular group. It's not, I don't see a particular age doing it more. Um, Actually, no, I maybe do see younger workers doing it more. Yeah, I actually that's probably the only dynamic I would see. There's between male and female outside of maternity. I don't see any. There's no preference. I don't see any particular groups. There's certainly in agriculture. I actually don't. I've seen it in admin positions quite a lot. I've seen it in those more fixed jobs, 9 to 5ers. Um, Where I have seen it on farms is that request for essentially more time off, for a better rota system. As we know, the farms tend to it's a mixed bag. 5 on 2 off is probably rarer. I tend to see 6 on 1 off, or I'll see they're working every second weekend during peak season. So let's be honest, they're working probably 7 days. I have had a recent one really awkward coming in from a shepherd, and as we know, shepherds pretty much work 7 days a week, um, because of the way they need to take care of livestock. Those can be the more difficult ones to negotiate, because in reality, you've got one person doing a very particular job, and to be able to adapt to a flexibility request where you can't recruit another person, it does cause complexities. And where this can fall apart is when the employer isn't transparent, cuts people off too soon, and isn't transparent enough during that sort of negotiation and understanding process. That's when the dynamic of the relationship can then fall apart, because an employee feels that they're not being heard, and vice versa. An employer is looking at it going, well, obviously we couldn't do that. You've seen this operation. That's where I can see it fall down the most. But there's no particular dynamic. I did have an example earlier this year where a request went wrong, formed part of a grievance process. Latterly, it became a big thing. This particular site used informal communication, as most farm sites do, as most agri sites do. They chatted about everything. Everything was known. This one particular individual had some medical difficulties, nothing that prevented them from doing their work that was to do with their back. Um, they were still able to achieve their work. There was some debate and negotiation about workload, but otherwise they were able to do everything. Um, they submitted a flexibility request to the employer formally, and it came in, and the two were sitting next to each other. The manager was there, the employer was next to him, and he said, yeah, go ahead. Yeah, I agree with that. And if you need to buy some supporting stuff for you, the guy was an office job, he needed a different chair. Just go and do it. But the employee didn't do anything. Despite that informal conversation happening, despite the manager thinking it was done, he didn't do anything. It came out in the grievance that he hadn't done anything, and it then transpired, as all things do, that I was turning around to the employer, the manager, and saying, well, even though informality is the communication style used, when it comes to things like formal requests, where they have a statutory right to things, when it comes to that, even if it's not normal, just send an email. That's the bare minimum. Just send an email, confirm receipt. And if you're agreeing something, just tick the box. It's a tick the box, agree it on paper. Otherwise, that whole relationship completely broke down after that. And it was something that was actually very difficult. I'm hoping my screen hasn't frozen. There we go. It was actually very difficult by the end because the whole dynamic had broken down. Okay, I'm actually running close to time. So I think I've got a couple more slides, but I'll sort of power through them because they're not, I don't believe they will be they will have impact, but not as impactful as some of the stuff we've discussed. Parental rights. So essentially what the bill is looking to do is to do a number of enhancements to parental rights. Maternity and paternity pay from day one. Currently, the employee has to have been employed with you for 26 continuous weeks before the 25th week of a pregnancy to be able to access pay. That will change. They can start with you today. They can tell you tomorrow that they're due a baby and they have access to the payments. Paternity pay is less painful. It's 2 weeks at the statutory rate, although I do recommend you just pay 100% because it's 2 weeks. It's not very painful for the employer and can offer a certain amount of security for the father, regardless. Maternity is a bit more painful because it's obviously 39 weeks of payments. At the statutory rate alone, that's a minimum of £7,000 being paid out for someone. And that doesn't take into account the first 6 weeks of maternity pay have to be paid at 90% of the salary. So that can be that could have some impact. That does not mean we are permitted to discriminate against people coming in for interviews, etc. But it's something to bear in mind. That example that I discussed about the flexible working request after maternity leave, that person went through the whole interview process, started working for this employer, and I think it was 2 or 3 weeks in, announced they were pregnant. And I've had that happen twice now within this year, that people have started working and very quickly announced they were pregnant. And farther on in their pregnancy, it wasn't just, I'm a week in. It was 12 weeks. We were already in the securer part of pregnancy. So potentially that money is coming. Parental leave will also become accessible from day one. Parental leave currently requires an employee to have been working with you for a year. It is 18 weeks of unpaid leave that can be used up to the 18th year of the child. And it can be used you can use a maximum of 4 weeks per year. It's to support employees during holiday periods, etc., where they've run out of holiday or they're trying to use their holiday entitlement wisely across the year, but actually they've not got cover during summer holidays and things. They can use unpaid leave. That becomes a day one right. Changes to paternity leave. So along with paternity pay, paternity leave currently is 2 weeks, which can be taken as continuous set of 2 weeks, or it can be taken as 2 separate blocks of 1 week. Always has to be taken after the birth of the child. And if the parents wanted to use shared parental leave, which essentially allows them to share a pool of money, so she's off for a bit, he's off for a bit, etc., etc. Previously, if he hadn't used his paternity leave before they went on shared parental, he'd lost it. The change is that he's now allowed to keep it and he can take it after. It's not going to be a massive impactful change, in all honesty. We're normally quite nice to paternity leavers. So Bereavement leave, mentioned this, it has been expanded. Outside of agri, there is no entitlement to bereavement leave. It doesn't exist. And whatever it is, it's unpaid. The AWO, Agricultural Wages Order, requires agri workers to be given 3 paid days. So already a massive enhancement on the general rules. The bill wants to increase bereavement leave, a statutory bereavement leave, to 1 week of unpaid for all workers with all eligible relationships. I suspect in agri we will see that 1 week unpaid be a 1 week paid thing. I think we'll see our 3 days go to 5. That is my belief. It has not been discussed yet with the wages board because this isn't law yet. That's what I would anticipate happening. Then, final one. This is a bit of a nasty one. Enhanced protection for pregnant workers and new parents. It's already very, very, very difficult to dismiss someone, whether through redundancy or any other means, if the individual is pregnant or if they've just returned from maternity leave. It's always dodgy ground. We try and avoid it anyways. Everyone does. It will now be unlawful to dismiss an employee or dismiss a pregnant employee or those returning from maternity leave for a period of 6 months after their return. That includes redundancy. Essentially, they become untouchable. The bar will be incredibly high if you do have to do a redundancy, but the protection, they've really clamped down on that protection. Again, potentially not something you will ever have to deal with, but certainly worth knowing that that protection does exist. And there is momentum to expand protection on parental rights. So even paternity leave, there are more proposals in place to increase it from statutory payments to higher payments, etc. There's all sorts in place for that. Don't know whether it's just my camera or not, so we're going to keep going unless I get flagged by anyone that this is frozen on me. No, okay. Genuine living wage. Mentioned this in the changes. The bill is going to look to change the living wage, and I'll explain how that impacts agri and AWO. Actually, to be fair, some of it will be less of a shock because of the AWO. Currently, we have the national minimum wage and the national living wage. National minimum sorted into age brackets. National living applies to anyone 21 and over. The proposals are looking to remove the age brackets. Well, some of the age brackets. All employees from the age of 18 shall earn a living wage. But that already applies in the AWO. Anyone 18 and over gets 12.21 an hour. So that's not unheard of. That's pretty normal for anyone in agriculture. Where it will change, and the one that I think probably will have an impact, is the living wage is currently not considered genuine because the calculation doesn't factor in all of the costs of living. The current genuine living wage calculation is apparently £12.60 an hour. Still feels not quite right, but it's £12.60 an hour. This is what I believe will happen, what I think will happen, is they would like to move everyone to the genuine living wage. So 18s and over, let's say that goes to £12.60. Outside of agri, most industries don't have a forced overtime wage. It doesn't exist. So unfortunately, agri suffers with the over 39 hours, all the criteria. Or 39 hours, everyone gets time and a half. What I think will be a challenge for order, is that the criteria that we have currently, or you cannot earn the overtime rate unless you've done the eligibility continuous employment. I think there'll be a challenge as to whether that stays in place or not, and if people should just be able to access overtime rate from day one. That is what I believe. That is not a fact that I know. I'm just saying that that's what I think might be a challenge. The one thing they haven't figured out, and again, the AWO, I've spoken to the enforcement team, there is no application for this. If you employ someone who is under 18, so 14, 15, 16, 17, technically and legally, there will be no bracket for them. I think the 16 to 17-year-old minimum wage bracket might remain, but 14 and 15s have no bracket. And therefore, there's no legislation that really covers them in terms of payment rates. So that'll come down to a reasonableness thing. I don't think the rules will look to change that, I have to say, but it's a reasonableness thing and always something to take into consideration. As you may have seen it in, thanks to the Courier who loves to publish it, you may have seen recently that more power is being given to the name and shame list. That is employers who are found to be underpaying their employees, even if it's a historic issue and hasn't just been fully resolved yet. Employers will end up on the government's name and shame list, which, as I said, the Courier likes to publish. In May alone, 7 businesses across Dundee, Fife and Stirling were named and shamed on the government list within the Courier. It's not a list you want to be on. And unfortunately, HMRC have made it clear that Scotland as a region is on their radar at the moment. You may have noticed more activity from the agricultural wages enforcement team, from the wages board, or from HMRC themselves within your area. They are focusing on Scotland for a reason. Not a list you want to be on. And when it comes down to calculations of wages, if you're struggling, just come and have those dialogues with us, because we do them all the time. And we can be very clear with what wages apply when overtime kicks in, when you have to do dog allowances, enhancements for skilled workers, etc. Just not a list you want to be on. I will give you one tip. I had an interesting conversation with a client the other day. HMRC have a really interesting approach. They will contact you as the employer to book a call to discuss an issue that they have identified. If you don't take the call, and they will tell you this, if you don't take the call or make time for the call, reasonable time for the call, they will proactively contact your employees one by one to ask them about their payments. So if you are contacted by HMRC to have a discussion, take the call. Don't, to a certain extent, protect the employees, protect yourself. Take the call, have a proactive conversation. They are much more responsive to that than you don't want people going. The enforcement team talks to your employees directly. They don't give you that benefit. So just be wary of that. Statutory sick pay. Okay, we're in the last 2 slides, I promise. Statutory sick pay. And I'll explain a little bit about how these work together. Currently, it's paid from the 4th day of the absence. It will be paid from the 1st day of the absence. Employees are entitled to 28 weeks. That's it. That's the change. Pay on 1st day. In the agri industry, agricultural sick pay is paid at a rate of 100% of the wage for 13 weeks. This is inclusive of the employee's entitlement to SSP, which some people don't seem to take into account. So when someone runs out of agricultural sick pay, they've done 13 weeks of it, statutory sick pay still continues for 15 weeks. Agricultural sick pay at the moment has eligibility criteria. SSP does not, so it applies regardless. I had a conversation with someone the other day and they said, oh, well, when they're off sick, we don't pay them because they don't get agricultural sick pay. They've not been with me that for long enough. I said, no. Well, one, tell me about their sickness pattern so I can figure it out. But 2, they're due SSP. It's already a right that can't be taken away. They get it from the 4th day of absence regardless. So if you've got someone off sick, ASP and SSP don't muddle how they are distributed. Everyone is always entitled to SSP. ASP just has some criteria. Okie doke. Final one. I'm just scanning my notes to make sure I didn't get anything because I know I'm rocketing through the end bit. I will say, before I move off at SSP, things that There are obviously complexities to when entitlements roll over and you get renewals, etc. Regardless of all that, and a word you've heard me bang on about, process, if you've got someone with poor attendance, odd days, make sure you're having return to work conversations. Those don't have to be documented. Just have that chat and even make a note to yourself that you've done it. What's going on? What's wrong with them? You're helping de-risk the business by identifying if there's any potentially underlying issues that you have to be aware of. Ensure that people follow standard absence reporting procedures, that they have to phone in a minimum of an hour before their shift to report if they're going to be absent, or text, whatever your preference. If they've been off for 7 days straight, they need to give you a sick line, no excuses. The GPs will give them to them. And they need to be sending you it. If they can't, some people will say, oh, well, the post. They can send a photo. They can send a genuine photo and then post it so you can get it later. You need it, push for it. If they've been off for a long period of time, have a return to work conversation. You want to know if they're fit for work. You want to know what their GP's saying. You want to know if they've been given any medication and how that impacts them. What if they can't operate heavy machinery right now? What if they've got antidepressants and it makes them tired? We need to know these things. It's our duty to know them. And also, and if you've got poor attendance, management of it. You can give out written warnings, sanctions for poor attendance. It's just part of the process. Again, if you're headed towards dismissal, it's a life cycle of an employee thing. Final thing, interesting conundrum, this one, the right to disconnect, otherwise known as the right to not communicate about work with your employer outside of your normal working hours and when you're not being paid. I'll clarify now. This was included in earlier proposal drafts. In April this year, it was officially dropped from the bill because it was cited as being a compliance burden, and no wonder. But I still have it in our clients' policies, not the full shebang because it was too difficult, but I still have a reasonableness aspect in terms of communication. So, and I'll go off some examples, but I'll just do this bit first. It's worth noting that this was in the proposals, that actually some of our European neighbours, and not far away, talking just about Ireland, France, Belgium, they have codes of practice about reasonable communication. As much as this has been dropped from the bill right now, I think it will come back up as a soft approach. They did discuss it initially. They just didn't get around to sort of sounding all out, and it became too difficult at the proposal stage. The soft approach means launching it through ACAS, which means that employers have a soft duty to abide by it. If not, compensation awards are increased at tribunal claims. That's basically what that means. But it's complex. It's complex, especially for agricultural businesses. If we'll go back to our shepherd, technically works 7 days a week, but odd hours. When are they working? When do we have to respectfully communicate with them or not? So when are the on hours and when are the off hours? If we have a dairy operation worker on a 6-1 rota, they're actually likely to have long breaks during the day, dependent on when milking is happening, on when other tasks are happening. Can we communicate with them in those longer periods of break, or does that count as a rest cycle because it's part of the longer working day, even though the break is probably unpaid for? What if we need people on call for alarms in hen houses or during lambing, calving? Do we have to be more specific about what an on-call window is, what communication is acceptable, and when the rest breaks are? It was considered challenging for other industries, generally be challenging, compliance burden. For agri, it would be ever so more challenging because we're very used to this informal communication method of just messaging, WhatsApp groups, back and forth, with no, because our operations, let's be fair, are normally a sort of 24/7 cycle. What I have suggested for our clients going forward, is, and if it went into law, it would all be formal agreements, definitions of emergency exceptions, definitions of acceptable and non-acceptable comms. What I have said to our clients, what I put into the policies, it's not a right, but it's a respect. Respect for we will not expect an employee when they're not working to check our communication. We might need to send messages so they get them at the start of their next shift. So we say, if you WhatsApp, mute the chat outside of working hours so that we can drop stuff in, but you are not under a duty to check it. Same with emails. If someone's not working, we don't expect them to check their emails if it's work-related communication. It's not something to get wound up about yet, but I will expect to see a soft launch. And it's something just to consider. How do you currently communicate? And are there ways that we can bracket off working hours versus non? Okay, I'm done. I'm done. I promise. Unless any questions come in. We've discussed overview of day one rights changes. This obviously will all be on the recording and everything, so you can go back and traumatize yourself some more if you would like. We've explained the 0 hours contracts piece and the alternatives with a slight segue into contracts of employment and probationary periods. Right to raise an unfair dismissal claim from day one, changes to flexible working, changes to parental leave, changes to living wage and statutory sick pay, and I keep an eye out for the right to disconnect. Those are the major things. Taking out that one. Those are the major things coming in the bill. I've already gone through the consultation stages. They have already had changes, but they are minor. They are minor. These will not massively differ now. It is just a question of when they go into law. And we've heard a lot that it'll be unfair dismissal claim. We've heard that'll be autumn 2026 because of the way employees are coming into businesses. To make it all fair, some of these will come in autumn this year. There'll be a bundle that come in. They always come in April, just because it's the start of the new financial year. So they will be coming in. They will rotate in. But for now, this is what you're looking at. And that's the kind of impact to employers that we'll be seeing.